Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello, listeners. Welcome to Tech Talks. Our topic today, China's data and cybersecurity laws. We'll be talking about the latest changes in those laws and the impact they could have on technology transactions involving parties in China and international data transfers. I'm your host, Julian Dibbell. I am a senior associate in Mayor Brown's technology transactions practice. I'm joined today by my colleagues, Gabriela Kennedy and Karen Lee. Gabriela is a partner in our Hong Kong office and co-chair of the global IP practice, as well as the head of our technology, media, and telecommunications practice in Asia. Karen is a counsel in our technology, media, and telecommunications practice based in Singapore. Welcome, everybody. Gabriela, I'd like to start by asking you to help us understand what companies might be affected by China's data and cybersecurity laws, and in particular, foreign companies. How can they be impacted by these laws?
Hi, Julian, and thank you for the question. Well, over the last few years, China has introduced a range of laws dealing with data privacy and cybersecurity. And this has resulted in a complex matrix of cybersecurity and data privacy. Some of these laws are sector specific and apply to regulated entities like banks or entities that operate mobile apps in China. However, the most overarching law, and perhaps the best known, is the Cybersecurity Law, which came into effect in June 2017. 4 years after the passing of this law, many concepts and provisions remain nebulous, as we are still awaiting further clarifications on some of the definitions in this law, or how many of the broad requirements will be enforced. Attention has also been more recently drawn to the newly passed data security law that has made some headlines. And this law came into effect on the 1st of September this year. In addition to this, a couple of days ago, the Personal Information Protection Law was passed, and this law will come into effect on the 1st of November 2021. So it all sounds, good and neat and simple, 3 new laws. But let's just start looking at some of these laws. And if I start by looking at the cybersecurity law, and in particular address your question as to how this might affect foreign companies. Well, simply, if you operate in a sector where any malfunction or data leak may lead to serious damage to national security, or the economy in general, or people's livelihood or public interest, then you will be categorized as a critical information infrastructure operator. I would call them a CII operator for short. And you will be subject to more stringent requirements. Some sectors that have been specifically identified as falling within the definition of a CII include the finance sector, utility providers, media platforms, e-commerce platforms, e-payment platforms, big data providers, cloud computing providers, and providers of enterprise systems. But the law doesn't apply just to CIIs. If you operate any IT networks or you have servers or websites in China, then you will be caught by the cybersecurity law as a network operator. Essentially, what I'm saying is that the law will apply to any entity with operations in China, which has some form of networked infrastructure. So, if you are a foreign company with an office or subsidiary in China, then your China operations would obviously be caught.
Okay, but what about foreign companies that don't have a physical presence in China?
Aha. Even if you do not have a direct physical presence in China, if you have service providers or technology developers or partners who operate in China, then you will be caught by this law, and indirectly this will impact your operations. Let's just think about, let's just look at it. If your service providers could provide major or minor services to your company, back office processing or cloud computing services, or could be developers of major technology components exploited or used by your business, a service provider or partner being subject to China's laws will also indirectly open up foreign companies to the scrutiny of Chinese authorities. So you're engaging with companies that have a presence in China, you're indirectly affected by these laws. For example, if a Chinese company that develops or manufactures major software or hardware components for a US company, and they fail to comply with China's cybersecurity laws, the Chinese authorities could open up an investigation against them, and this will indirectly result in the US company's data or confidential information being scrutinized by the Chinese authorities. So that's just the China cybersecurity law. But I mentioned at the beginning two other new laws that are coming into play, the data security law and the personal information protection law, freshly passed. They have been specifically drafted to provide extraterritorial application to foreign companies with no presence whatsoever in China. But if these companies process data of Chinese citizens or Chinese organizations, they will be caught by these new pieces of legislation. In particular, the data security law, which was passed in June this year and which has just come into effect on the 1st of September, sets out a framework to regulate the processing of data, which is defined as any record or of information in electronic or non-electronic format. China cybersecurity law applied just to electronic formats. Now we have a data security law that is very broad and applies to both electronic and non-electronic records. The coverage of this law goes beyond personal data. It expressly states it will apply to data processing activities outside China if such activities would be detrimental to national security or to the public interest of China or to the lawful rights and interests of Chinese citizens and companies. So a similar provision appears in the final version of the Personal Information Protection Law, which was passed on 20th of August and is set to come into force on the 1st of November. In fact, this new personal information law goes even further. It expressly applies to anyone outside China that processes personal data of individuals located in China. If this data is, or this activity is for the purpose of providing products or services to individuals in China, or if you're analyzing and evaluating the behavior of individuals in China, or any other circumstances stipulated by local laws or regulations. That's very, very broad and very malleable provision. There are some parallels between this new law and the GDPR, but I would say the personal information law of China is drafted a bit broader. Can you imagine that? May mean that even if a foreign company is not specifically targeting individuals in China, but just allows global delivery, you have a global website, that law would still apply, as the company could be processing personal data of an individual in China for purposes of delivering a product they've ordered or providing a service that they have ordered. Also, any data controller outside China will have to establish a dedicated office or appoint a representative within China to be responsible for personal information protection. Of course, I've oversimplified these new laws. There's so much more, and we will learn so much more as new regulations come in under these laws.
Well, broader than GDPR, I'm still trying to process that. And obviously, companies are having to think constantly about GDPR in the context of technology transactions. What are some of the key things that foreign companies need to be aware of around these China laws in the context of their technology transactions? Karen?
Well, companies really need to be aware of their data flows in and out of China. It seems quite obvious, but it really needs to be taken into account when preparing any technology transactions. Foreign companies also need to ensure that any partner or contractor in China that they're contracting with is fully compliant with China's data and cybersecurity laws. As mentioned by Gabriela, if they're in breach, then this really opens up the partner or contractor to an investigation by the Chinese authorities, which could indirectly impact the foreign company. So, for example, it could stall the foreign company's supply chain or expose its confidential information that's held by its Chinese partners or contractors to the Chinese authorities. It's also really important for foreign companies to include, the appropriate warranties and undertakings and indemnities in their agreements with their Chinese counterparts regarding compliance with the local laws. But also they have to conduct the due diligence on them to make sure that they are actually compliant rather than just relying on these warranties and undertakings. It should also be borne in mind that companies that meet a certain classification level or who are critical information infrastructure operators can only use certain software or other products in relation to their network or which may impact national security if the products or services have been certified by the relevant local authorities. So essentially, it can make it really difficult for companies in China to deploy foreign cybersecurity or other network products or services. So we sometimes see clients use different network and cybersecurity products for their operations in China to those that they use globally. A lot of the requirements under China's data and cybersecurity laws could have an indirect impact on technology transactions, particularly since non-compliance may result in investigations by the local authorities, as I've said. So, most companies, they usually focus on the restrictions placed on cross-border data transfers, but then they overlook other important parts of the cybersecurity and data privacy laws, such as the requirement to undergo a security assessment in accordance with the multi-level protection scheme and to deploy, security measures according to their risk classification level. So those are also important things that need to be borne in mind.
Okay, but at the same time, as you mentioned, cross-border data transfers are also an issue. What are the current restrictions on those?
Yeah, that's a good question. For a while, there's been data localization and cross-border transfer restrictions against critical information infrastructure operators under the cybersecurity law, which the government has tried to sort of expand to network operators by, various draft measures. The effect of the new data security law and the personal information protection law is that it has effectively expanded the scope to make all entities subject to some form of cross-border transfer restrictions. When a company processes data with a China nexus. So for the data security law, it restricts overseas transfers of important data by any entity. Unfortunately, we still don't have a clear definition of what important data is. Hopefully we'll get more clarity in the next few months. Under the personal information protection law, no one can transfer personal information outside of China unless they obtain the individual's consent, and they either get a security certification obtained by an accredited body, or they enter into a standard contract with a foreign recipient. So the standard contract will be one that will be issued by the Cyberspace Administration of China, or the transfers in accordance with other laws or regulations. However, if the entity is processing personal information that exceeds a certain volume that will be specified by the local authority, or if they are a critical information infrastructure operator, then they have to store the data in China, and they can only transfer the data overseas if they pass an official security assessment. So it's also important to remember that the cross-border transfer restrictions even apply to remote access. So if someone in the US is accessing the local system of its China operations, this amounts to a cross-border transfer of data. So it can be quite complicated and quite restrictive.
So I'm wondering, though, about data transfers that are required by foreign authorities or foreign courts who have jurisdiction over the company. How are those handled? Are there any accommodations for those?
Yeah, that would put companies actually in quite a tricky situation because of the new data security law and the new personal information protection law. There's a provision saying that if a foreign judicial or law enforcement authority asks for data that's actually stored in China, you are not allowed to provide it unless you obtain the approval from the relevant Chinese authority, or it's in accordance with an international treaty or agreement that applies. And any breach can actually result in quite a substantial fine. For example, under the data security law, it's about $780,000 US. And there's other penalties as well, you know, revoking the business license or suspension of services. And any individual that's seen as directly responsible could also face some penalties.
Okay, well, we've now heard about quite a lot of requirements that companies are facing with respect to these laws. Gabriela, what in your experience have you seen companies looking to do to address the requirements and comply?
Yes, it's a very good question again. We have seen companies that have started segregating their data and operations in China to keep them separate from their global operations. So, for example, with cloud services, we have seen companies entering into separate arrangements for their China operations compared to their global operations. This is because many of them want to minimize any backdoor access to their offshore data. And it also makes compliance with the local laws easier. For example, compliance with network security obligations, which, by the way, involve the use of products and services approved by the Chinese authorities, or just simply in order to minimize the volume of cross-border data transfers and inevitably the bureaucracy associated with obtaining approvals for such transfers, which can be quite painful. So, but as mentioned by Karen, it's also important that any transaction that has a China nexus, for example, you have a Chinese partner or a vendor that provides services to you from China or does processing of your data in China, or you process data of China residents, that you have appropriate warranties, undertakings and indemnities regarding compliance with China's data and cybersecurity laws, and now also the new personal information law. So if the Chinese counterparty is not compliant, and they run the risk of an investigation being launched against them. And if they are found to be non-compliant, they can have their business license suspended, which inevitably would affect your operations as well.
And what kind of enforcement are you seeing of these data and cybersecurity laws? Has there been active enforcement of the laws in China?
So we have to remember that the data security law and the personal information law are brand new. So no enforcement yet. They've just been passed, and we're expecting lots and lots of regulations to come up to clarify some of the issues, some of the definitions that are quite broad under these two laws. However, China cybersecurity law has been in force for over 4 years now, and there has been some enforcement. Most of it has been focused on mobile applications and their collection of personal information. The authorities, however, have also been looking at ensuring that companies put in place security measures that are compliant with a multi-level protection scheme that Karen was mentioning. So most recently in July, the Chinese authorities have targeted 4 US-listed mobile apps. That's first, before they focused on local mobile apps. The investigations were launched on the basis of protecting national security and the public interest. And the companies were accused of breaching requirements relating to the collection and use of personal data. It is likely, we think, that we are going to see more investigations and scrutiny now that the data security law has come into effect. And the focus there is on the security of your networks. And there's an obligation to have training for your staff, to have people who are responsible for ensuring that this happens. And also there will be more enforcement under the personal information law that has just been passed, especially issued to provide clarity on the application of these laws. So again, taking you back to the data security law, this requires government authorities to carry out national security reviews of any data processing activities that could affect China's national security. and processors of critical data must conduct regular assessments and submit them to relevant authorities. Of course, the million-dollar question is, what is critical data? And we're awaiting to know what that is. So in conclusion, foreign companies really need to ensure that they have the appropriate provisions in their agreements with their China counterparts to protect themselves in the event that they become subject to investigations by the Chinese authorities. For example, being able to exit the agreement swiftly in order to find alternative vendors and to get indemnified for the costs suffered by the foreign company due to the impact of an investigation of the Chinese vendor.
Well, thanks very much, Gabriela and Karen. Thank you both for your insights. Listeners, if you have any questions about today's episode or an idea for an episode you'd like to hear about anything related to technology transactions and the law, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.